law questions. Yes, though you are not law students, but at least you need to know how law questions are answered. The questions may come in twofold. It may be a direct essay, okay, a direct essay question where you have to discuss or explain. Then it could also come as a problem question. When it comes as a problem question, where the last part of the question, after giving you the fact of the matter or the fact of the case, and they ask you advice as a lawyer, advice, or as a manager, advice, it means it's a problem question. Such a question in the law faculty, you will be taught what you call IRAC. Sometimes you can do away with this and you become IRAC or ARAC. If you add this, it becomes ARAC. You can do with this and you are fine to go. Okay? Where we say area of law. Assume I'm trying to open a question here. Okay? A question here for us to look at what we are talking about. The area of law, if the question borders on capacity, if the question borders on offer and an acceptance, if the question borders on, what's the name? An intention to create a legal relation, okay? That is when you tell the examiner the area of law. So if it's an issue of a contract between A and B, and what they're actually looking for is an issue about consideration, then you will say what? Consideration, area of law, consideration, either with a specific reference to what the question is talking about. Then two, the issue, what is the issue that has become the problem? Because when you go to court, if you have ever seen a court judgment, the issue that the judge must hear is the problem between the two parties. Okay, party A brought a case to court. Party B brought his or her response. So what is the issue? What is the issue that the court must settle for the two people? So that is what you do. So most of the time, if you have ever seen a judgment or a document from court, you will see that the issue, they write whether or not Kofi have a case against Amma, whether or not the issue at stake is right or wrong. So that is the issue that must be discussed. So sometimes they will present one passage or a part of case to you. Out of it, you can have 2, 3, 4, or as many issues, and you resolve them accordingly. Okay, please, are we together? Then the rules. The rules here, we are looking at the laws. What does the law says? The law says that when there's a contract between a minor and an adult, that contract is void. That is the rule, or what you can say the law. If you sign a contract with a minor and it's not a contract of necessaries, and we know necessaries are things that are needed for the betterment of everyone's life, such as food, such as what, clothing, such as shelter, education, training, are all things that a minor, somebody who is not up to the age of 21 years, can engage in such contract and is valid and is binding on that party. So the rule says A, B, C, D, and that is when what you talk about what the rules is talking about. You look at the fact of the matter or the case before you, then you see what rules apply to those issues. Now, after you have digested all the rules that you know of, how does it apply to the case before you? How does it apply to the matter or the problem that has been brought to your chamber as a lawyer to resolve? Then after that, you can conclude. Please, are we together? So, are we together? Yes. References. Okay. What you want to make, you want to draw attention to is the rules. You are going to make references to a particular case. That is the rules. Because if you want to pick a case, for example, yesterday I wrote an exam on jurisprudence, And then one of the issues is that the case between Kwate and Kwate, we want to make reference to that case. That was on issue of matrimonial settlement. And it's an issue of constitutional provision that if you marry or if you are in a marriage and the two of you build property and there's a separation, the other spouse should not go just like that. There must be some benefit. There must be some reasonable provision. This is the provision of the law. So when you want, if there's an issue on marital divorce that has come to you, and as a lawyer, they say advice, whether Madam A should go to court or Mr. A should go to court, you are making reference to what? That case. It will come under the rules. Please, are we together? Then you then apply it. Does the case of Kwate versus Kwate apply to this case before you? If no, then you don't bring it. But if you bring it, then you are bringing the wrong authority to justify a different matter. Because when you look at the basis of the law or the common law that we practice in Ghana, where we look at judicial precedent, the case that has been decided in the past, if a similar case or the same case is before you, for the purpose of continuity and consistency, the law will make reference to the previous case. That is the issue of the judicial precedent. So if the case is a marital divorce or spousal divorce case, and you want to make reference to Kwate versus Kwate, or you want to make reference to, what's the name? Marriott versus Marriott, or Bafo versus Bafo, know the context of what the case or the issue before you. Then when you apply it, then you conclude that based on ABCD thing, if Madam so-so and so proceed to court, she will win this case, or she will be compensated for a wrongful divorce or any other. So that's how you conclude. Okay. But the issue is that I'm giving you these areas or the format of answering law questions on the basis, you are not a law student here. Okay. And after this course, you will not make one a lawyer. You have to go through the process and be called to the bar. But tomorrow, if somebody asks you, oh, you say you have done business law, how do you answer question? At least you know that this is how a problem question is answered. My questions I'll bring to you in this exam will be a passage. Okay. I may ask you to maybe pick the element of what? The valid contract and explain, discuss. Okay. Because I know you are workers, my mothers, my fathers here, will not burden you like the first degree student who is reading law for 3 years continuous, for them to go through all this in an exam. Because the Makola question that they always fail people, this is the format. If you're not able to get it in that manner, and it's not the direct one, which is the essay type, even if you're answering an essay question, it is required that you apply the format of these things in it. We want to continue with the class we're having the last time on offer and an acceptance. Yeah, let me look for the question I wanted to discuss with you today. Or if you know them, why don't you why not? You can use them. Like I said, if you want to quote a case, if you want to quote an article or a statutory provision, please, if you don't know, just paraphrase. The moment you go and put this word, we all know. It means that you are giving that exact information. Because you have put quotation mark. It means you are quoting something. Everybody should be able to go there and see exactly what is there. But if you know you cannot remember, you want to quote Article 22, what is there, and you cannot remember what is there, just say that in Article 22 of 1992 Constitution, just brief this for us. Okay, everybody can go and know the import you want to make with your argument. But if you want to put quotation mark, it means that you are giving us exactly what is there. Please, is there any question on offer so far? Hello? Any question on offer so far? You want to go to acceptance. Uh, let's look at this question. Mr. Ransford and Dr. Afo have been friends for the past 4 years. Mr. Ransford offered to sell his tipper truck to his friend on the 10th of January 2024 at a price of 120,000 Ghana cedis. He kept the offer open till 17th January 2024. Dr. Afo wrote back to Ransford on the 13th January 2024, asking for a further and specific particulars of the truck, including the current state of the engine, the color of the truck, the year of manufacture. Mr. Ransford opened the receipt of the information. Mr. Ransford, upon the receipt of the information, sold the truck to another buyer on the 16th January 2024. Dr. Afo contemplating going to court and has come to seek for your legal opinion. What will be your advice to Dr. Afo considering the fact of the case? So this case is a problem type of question. But this one particularly is one of the basics of the problem question. This is just an issue of offer and acceptance. This one has not even gone to the stage of consideration. Do they have the capacity to engage in contract, or do they have the legal relation? We've not gone there. It's just a simple issue of offer and acceptance. So when you see something like this in exam, you see that it's a bonus. Because this one, nobody is asking you to go by Iraq. Your legal opinion. Your legal opinion. So the opinion that you have to give to what Dr. Afo in this case is what you have to what, look at. Now we've dealt with offer. We've gone through the various stages. We've gone through what is called a mere inquiry. When a party is asking for information and the information is misconstrued to be what? A rejection. What you should do, okay? And when offer is valid, is open for a period, and the offer has not been accepted, the period has not elapsed, that is lapse of time has not come, doesn't mean the offer is closed. And this offer is a what? A bilateral offer made on a person, not made to the whole wide world. It was made on a person. And the law says the person has to the end of the time. It's not able to accept offer. Then you can what? You can give the offer to another person. This was a mere information that was being requested on Mr. Ransford. But he took it to be what? A rejection of the offer, or he took it to be a counter offer and decided to what? Sell the car to a different person. So now we want to look at acceptance today. An acceptance must be accepted. An offer must be what? Accepted totally by express, oral, or written words, or by conduct to constitute an agreement. So in the case of Fofie versus what? Zanyo 1992, the majority of what? The Supreme Court held that an acceptance that had not been what? Communicated was ineffective in constituting an agreement. So I say I'm selling my laptop to you. Please, the name is. Come again. Ayariga. I'm selling it to Ayariga. This offer is valid for 3 days. I'm giving it to him 1,000 cedis. Okay. He called to ask what is the capacity of the laptop. I've given him all the information. 3 days, if he hasn't come, then lapse of time will take place where we can say that that offer is no more available. I can give it to another person. But if he has accepted to buy this laptop and he did not communicate to me, what does it mean? It means he has not accepted the offer. So the court says what? An acceptance must be communicated. If the acceptance is not communicated, it is not concluded or is not constitute what? An agreement. So an acceptance of offer must be communicated by the offeree or an authorized agent of the offeree to the offeror before the offer is revoked by the offeror. So if he has accepted to buy the laptop and the offer is for 3 days, within these 3 days, he has not communicated to me, or maybe he has not told the course rep that, oh, please, if you have Frank's number, tell him that I have accepted the offer. So he should keep the laptop for me. Okay. If nobody communicates with me for 3 days, after 3 days, I'm supposed to what? To give the offer to somebody else because I've not had any agreement with him. So Dr. Ransford and Dr. Afu, you will see that no acceptance has been communicated. So once Dr. Afu has come to you for your opinion, know that one, he hasn't accepted the offer. He made an inquiry. And after that, he's supposed to indicate his acceptance expressly, either writing or by conduct. Okay. Let's continue with that. Okay, so come again. Yes, that is the offer has been given for 3 days. Yes, if I say I've given the laptop to you for 3 days, that means that you have 3 days to make a decision. Within that 3 days, the law allows you to make inquiry, to know what you are buying, whether it's the specification that you're even interested in, whether you are okay with the price. But the moment you also bring a new price, automatically you have rejected the offer I've given you. You are now bringing a new offer. Because from what we learn in offer, if you make a changes to the offer, the terms of the offer, it means you have introduced a new term, which constitutes a rejection of the existing offer. So acceptance must be communicated. So it is a final and unqualified expression of assent to the terms of an offer, and the mere acknowledgement of an acceptance does not constitute an acceptance. Acknowledgement of an acceptance does not constitute an acceptance. Okay, and it implies that acceptance must be communicated to the offeror. So if you don't tell the person who has given the offer that I have accepted, okay, to the terms of the offer, it does not mean, oh, I have acknowledged. Okay, yeah, I've seen your offer. I've seen it. I've seen it. Yes, that alone, the law says, doesn't constitute an acceptance. Please, are we together? The offeror. The offeror is the person who is giving the offer. The person giving offer. Yes, I'm the one selling the laptop. So in this case, I'm the offeror. Okay. And the offeree. Come again. The one receiving. So you are the one who has been given the opportunity to make acceptance. So when you accept, then you become an offeree. So in the case of Powell versus Lee, the board of a school managed by what? The defendant resolved to appoint the plaintiff as a headmaster after the plaintiff had applied for the position. The board did not agree on the manner in which the acceptance of the plaintiff application would be communicated to him. A board member who had not been authorized informed the plaintiff that his application has been accepted. Consequently, the board decided not to appoint the plaintiff as headmaster, which prompted the plaintiff to sue for a breach of contract. What did the court say? The court held that the purported acceptance was ineffective because it had not been officially communicated to him. Now, those of you who are a bit current, let me just take you to our sister university here, TATU. Those of you who are current. TATU declared a vacancy for their vice chancellor not long ago. About 7 professors contested for that position. 1 was from outside the country. And then 2 are from Lagos. 1 or 2 from UDS, and 4. The total number is 7. Okay. So, yes, 4 are within, 3 are from outside. Then it became a 2-horse race, thank you for the word, between 1 professor in UDS and the current pro-vice chancellor of the technical university. Okay, so what happened? Before the final decision is taken, then some people started congratulating the professor from UDS for being appointed the vice chancellor. That is an example of this case here. A headmaster position had been declared vacant. Then my brother applied. I was a panel member. Then because I know him, I said, oh, Charlie, we have accepted you. Then he has gone around celebrating, jubilating that he has been made the headmaster of the school. Without official communication, just like the scenario I'm giving you. So a professor from UDS was already congratulated on all our pages on campus. UTAG, the general university page. Oh, Professor this, congratulations, Professor this. Then I called somebody who is in his office. He said he doesn't know who has decided to be Okromaf. They have not given official communication yet. As to how the matter came out from council meeting, that he is a chosen one, nobody knows. Because they are also of the view that the university is considering an in-house person, which will give what we call organic growth. Okay, so this will encourage people to work within and grow within. So let's wait for official communication. Then people are celebrating the professor from UDS. 3 days time, the official communication came. Then the pro-vice chancellor of the technical university has been elevated as VC. Now, what happened to the professor from UDS? Assuming he goes to court that he has been appointed vice chancellor of TATU, this is how he will lose the case. Because there has not been official communication to you. When you are applying, they did not tell you that a member from the committee will tell you that you have been appointed. There will be official communication, giving you your terms and conditions, terms of reference of your job. So when acceptance has not been officially communicated, it doesn't constitute an acceptance of an offer. So I'm giving you that scenario just to explain to you what this case means. Okay, and these days people are fan of that. They want to be the first to break the news. They want to be the first to break the news. Something that somebody is doing on is quiet. Oh, he wants to be the first to break it down. I know about him. That's the problem. Yes, Neil. Yeah. Yes. How did you apply? Yes. So at all costs, the manner which should be done, whether communicated or not communicated, should be official. It should be official. They say a member, not even a chairman, a member met you outside and told you that, oh, you have been accepted. And you also concluded from that point, you're going to change your wardrobe because you know you have been appointed headmaster. So when finally the appointment didn't come, he went to court. And the court said that no, you don't have a case because the purported acceptance was ineffective because it had not been officially communicated to you. So the question is, what is the capacity of that person? Capacity as a board member. You see, everybody if we learn what to call ultravirus, everybody have his powers. And when you exceed your powers, it becomes an ultravirus. That ultravirus needs to be ratified by the shareholders or the other board members. So if what you have done has not been ratified, it means that you lack the capacity to do it. That power to do that, you don't have it. So you are doing it wrongly. And like I said, what happened here? Okay, if not, most of us wouldn't have known that our revered professor is looking for a position somewhere. Please, you see the scenario? Now, if everybody seeing it, I say, so you also attempted. So you also attempted. So you also attempted. You see the embarrassment it brings about. Keep quiet. Let the process be officially completed. If we communicate and we hear he's the one, we will celebrate him. Okay, we will celebrate. Yes, sir.
It was communicated that you feel the information from one of us.
Yes, that's why I say the manner that acceptance will be communicated has not been decided. If they decided, or the advert says that your acceptance to the position will be communicated to you by any of the board members or the selection committee members, fine. So that when you hear from one member, you have heard from the group. That is where you have to now contest the case. Yes, sir. So please move to another one. Yes. Okay. Please then go back to the definition. Aura.
One of the members will communicate with him.
So you're also talking about the manner. That manner has not been defined. This is a definition of acceptance. So our brother is introducing new facts into the case.
Then at the end, one of the board members or the panel tries to communicate with the person. Not it's oral. There's no documentation. You have not recorded.
I get what you are saying. You see, we said that offer can be made orally, written, or by conduct. The same format, acceptance can also be expressly written, oral, or by conduct. Okay, you have introduced a new fact to our case. Our case is that the manner in which acceptance should be communicated has not been decided. But we all know that an official institution that is looking for a headmaster, they publish it. You apply, you were interviewed. The best way is that they will write back to you. It's official. They made an announcement. We are looking for a headmaster. Anyone qualified, 2 years experience, so and so. It's an oral offer. You come orally. You should expect your response orally. Yes, madam. Hey, if it's still in the court, be careful so that we are not held for contempt. Okay. Wale case. Hey, no, unless you brief us. Unless you brief us. Which of the primaries? MPP, okay. Okay. Mm-hmm. Is it, what's the name of the gentleman name? Mahama, something, Kabiru Mahama. They call it, is it KB or JB or one of them? KB, yes, yes. Mm-hmm. Mm-hmm. Ballot. Is that my food? Then let me drink the water. I beg you. Sorry, left. Mhm. The case to court. So the brief of that matter, though I've not read the full story, is that they've annulled that election, that he shouldn't carry himself as a parliamentary candidate. So the party is now working on their modalities. Now, as we speak, when it's an issue of election, there's an ally that governs election. Those ally will spell out the do's and the don'ts. Those who have the right to do A, B, or C. So as we are going to 2024 election, you see that EC is going to present an ally to regulate this election. So that after this election, if any petition should come, how long it should be handled. So the court through the judicial system will also come out with their timetable. That if there's a presidential petition, because we don't want 2013 case where Mr. Mahama have to spend almost 11 months or 10 months not knowing his position, whether he's going to be the president or he will be challenged to rerun. Okay, so because of that, the 2021 was given just 40 days or so to decide, and we had the way forward to allow whoever become the president to work. The ally that regulate the constituency elections, and that is even their party election, not just national, it's party. Okay, so we need to know the party constitution, the procedures that is out there. Then, if you invite electoral commission, what is their position? Are they neutral people, or they are also subject to the party leadership to take decisions? So all these things must be brought to bear. Then we see where the wrongs or the crime which has been committed came from. Okay, so my side of the issue is that for every case that you want to bring your opinion on, know the facts. Know the fact. If you don't know the fact, then you want to use a different authority from somewhere to resolve what is before you, you make mistakes. Yes. So for the election issue, I'm not vested in them for now. So I will not give an opinion which I don't have. Which year? This year. My brother, let's go. So please, thank you very much. So let's go to, yes. Now, acceptance can be done silently. So he said, wait. It depends on the terms in the offer. So silence does not amount to acceptance. But where it is written in the offer that if I did not hear from you, I will presume you have accepted, then that one, silence becomes an acceptance. But the general rule is that silence does not constitute or amount to what? Acceptance. Okay, now let's look at this case. Third House versus Burnley, 1862. An uncle was negotiating with his nephew to buy a horse. The uncle wrote to his nephew, offering to pay a certain sum, and stated if he does not receive any response from his what? Nephew, he will consider the horse as his. So it means that the offer is saying silence become acceptance.
It's like the uncle wrote to the nephew. In case what the uncle wrote to the nephew didn't get to the nephew, and you assume that because the nephew didn't reply to you, it means yeah.
So that is what we are looking at. The nephew did not respond. It means he has received it. He has received it. In this case, unlike your mother. The nephew did not respond, but told an auctioneer to remove the horse from an auction. What happened? The auctioneer omitted to do so, and the horse was sold to a third party. The uncle sued the auctioneer. And what is the court decision? The court decided that there was no contract since the nephew did not communicate his intention to accept the uncle's offer. Silence cannot amount to an acceptance in a bilateral. So the condition is here. Bilateral, a contract that has been given to you. Okay. But a unilateral contract like the Carlin versus Kaboli smoke ball, you don't need anybody to come and tell you, I have accepted. That's why you made an offer to the whole wide world. Anybody who buys or who accepted by purchasing the medicine, use it according to what the instruction have accepted. And that is where silence becomes an option. But in a bilateral contract, silence cannot be what? An acceptance. Yes, sir. So this is an offer issue. And we are looking at acceptance. Okay. Oh, you see, when you look at what is happening here, the horse is supposed to go for an auction. Please, an auction. An auction too, we know, is not what? A complete offer. It's an invitation to treat. So it means that there's a period within all the thing is happening. I expect you to buy the thing. Instead of you to communicate back to me that you have accepted, you decided to tell the auctioneer that please you remove this horse and put it aside. Indirectly, you have accepted, but you didn't communicate. So silence. And the law is saying that silence in a bilateral contract does not amount to acceptance. So here we are not looking at the number of days you have to make decision as to whether you accept or not. It means that all the opportunity have been exhausted, but he did not communicate. That's what they mean. Yeah, let's move to the next one. A unilateral contract. So these are the exceptions to the silence. A unilateral contract, an acceptance may be by silence in a unilateral contract. And you see that Kalik has come here again. Silence in a unilateral contract may amount to an acceptance since the offeree may waive the need for communication of acceptance. If you buy Procode by Kojak, do you have to call the company and tell them you bought Procode? I bought some. Up to now, my code is still there. You can hear it in my voice. Somebody, a pharmacist asked me, but me, I use it gold. Why can't you? It's not going. I say, my blood is different. This watch I'm wearing right now, I guess whether it will last to the end of next month. Anything engine, particular what that I put on my skin, it will not last for 6 months. It will go off. It will go off. A friend of mine tried it. He thought I was just bluffing. He brought Casio. We all know that brand, Casio, that watch from UK. He said maybe what I'm buying a Chinese product. Then he was coming back from UK and brought the Casio watch from UK. We all expect the standard to be good. I wore that watch 3 months before he went back, stopped working. Then I showed it to him. That there's the blood I have. That is why if a witchcraft bites me, they die themselves. It's a poisonous blood. So
Yes, sir. Lawyer, I have a question.
okay, somebody have a question online. Let us go ahead. They should ask.
To the slide.
Or they are typing it.
No, I want the slide, the acceptance, the silence something. The one before this, please.
Are you asking a question or not?
Yes, I want to ask the question based on the slide. The slide before.
Yeah, so go ahead. Speak loud because we are not hearing.
Whether it's the exception or the silence.
What's your question?
Okay, my question is that the uncle could have rather sued the nephew because he has his contract with the nephew, so that the nephew can translate that to the auctioneer. In that case, maybe the uncles may have a case.
You should come again. Let's get.
Can you come again? Your question is not clear.
That's why I want to see the slide, please.
Which slide?
Yeah, third house, this one.
The third house, the silence slide. Okay, go ahead.
Thank you. So if I were the uncle, I would have sued my nephew because I have the contract with my nephew and not the auctioneer. so that my nephew can cascade the action to the auctioneer, because my nephew is also having his own contract with the auctioneer. So in that case, how would it look like?
In that case, what will do? What?
How would it feel like? What would have the court hold?
How would the court?
So you should let us know the real meaning is.
So your question specifically is that
If the uncle should have sued his nephew, what
uh-huh.
would?
So if the uncle sues the nephew, what would be the ruling? Is that what you're asking?
Yes, what would be the ruling?
He said if it was him, he would have sued.
Okay.
Not the
Please, did you understand his question? That if he was the uncle, he would have sued the
nephew.
So let's look at the fact of the case again. What did he say? Tell him he should follow us. Want to look at the fact of the case. He said the uncle wrote to his nephew. The uncle wrote to his nephew, okay, offering to pay a certain sum, and stated if he does not receive, what from his nephew, he will consider the horse as his. So if I tell you that if I don't hear from you, the phone is yours. I didn't hear from you. The presumption that the phone is yours. So in this case, the uncle knows that the nephew has accepted his offer. But instead of the nephew letting the auctioneer know, or he has, from the story we have, or the fact, the nephew did not respond, but told an auctioneer to remove the horse from the auction. So now the problem is that the auctioneer forgot. That's why he said omitted. The auctioneer omitted. So what our senior brother is asking, that should have sued the nephew has not committed any crime. So per the fact we have, the presumption is that the nephew have accepted the offer. Because the term of the offer is that if I don't hear from you, I've assumed that you have taken the offer. Even though the law is saying that what? In a bilateral contract, silence cannot be what? A mode of acceptance. Okay, except in what? Unilateral contract. So in that case, our brother, if he's an uncle, is trying to expect that. Since my son is silent, the auctioneer should also know. That is where silence is not accepted in a bilateral contract. Because if he had communicated, everyone would have heard it, including the auctioneer, would have seen an acceptance made on the particular horse without keeping quiet, and that has made also the auctioneer to forget and omit from taking the horse out of the lot. So the problem is between the uncle and the auctioneer, not the nephew. That is why our brother's case, thank God he's not the uncle. But if he's the uncle, the problem is that it is not your son or your nephew who decided to omit the process. It is the auctioneer. The nephew has communicated to the auctioneer, and the auctioneer omitted the process by allowing the thing to go through. So let's go to the next one. So we see the exceptions to the silence, and the major exception is the case of what? Khalid versus Kaboli smoke bomb, where we are told that the offer to the whole world was held to be capable of being accepted without communication of acceptance. So they have made an offer to the whole world. And you see the money that was put in Alliance Bank is £1,000. The offer says if you use and it fails, we will give you £100, right? It means that there's still £900 out there. So there's so much commitment to that offer. So you don't expect to communicate that, oh, I have bought it, so I will use it in case it fails. I'm coming for it. You don't need. So that is what we are talking about. So acceptance by post, like I said, if you look at the cases we are making reference to, 18 something something, telephone was not there, telegram was not there, internet, WhatsApp were not there. This was the most of the means of communication. Post office. I'm sure that there are people in this class who will remember that they wrote love letters when they were in SS? I know most of us who are young, we didn't engage, but most of our senior citizens here will attest that they wrote it when they were in SS. Those days when you wrote, you posted it. Now, we are saying that when offer is made, acceptance can be communicated. What is the process? So acceptance by post. An acceptance communicated through the post is deemed complete and effective as soon as the letter is rightly addressed and posted. So you see that those days, when you are buying university form, they put 2 small envelopes in a bigger one. The bigger one is the one that contains the form. Okay? The university is supposed to communicate back to you whether you have been given admission offer with one of the small envelopes. The first one, then they'll send the second one. So they always put 2. They always put 2. Now, so it means that if you provide an address which is wrong, and they post it to that wrong address, the law says what? Communication has been completed. If you provided the address and they chose a wrong address, then they are wrong. But if you have given them address, and that is why they even ask us to address the envelope ourselves, it's all because of this case. They don't want to fall foul and say, oh, they've asked some national service people to fill the address and they made mistake. So those days, they ask that you fill the form, the envelope with your own address, so that if the university have accepted your invitation, the tender process, admission process, they pick your own, the so and so cost. Oh, you have aggregate this, you have this, cutoff is this, you made a cut, and they pick you out of the lot. Then they will now give you an offer by giving you an admission letter and post it to you through an address. The law says that when the address is correct and the letter is given to the postmaster and they stamp it, it means that acceptance has been communicated. Yes. Because in the terms of that offer, acceptance by post is a medium of communication. That's what the law says. An acceptance communicated through the post is deemed complete and effective as soon as the letter is rightly addressed and posted. So where the parties envisage that the post will be a mode of communication, the postmaster will be deemed as an agent of the parties. So the moment we say that, okay, acceptance will be by post, it means that the postmaster is our agent. When I give it to the postmaster, I have finished my work. It means I've given it to your agent. Please, are we getting the picture? As to how that document will get to you is no more my case. So this case here, Adam versus Lindsay, 1818. On September 2, let's look at the date here. Please, let's take note of the date. On September 2, the defendant wrote a letter offering to sell wool to the plaintiff. The defendant indicated that the acceptance should be by post. The defendant is the one who is giving the offer. In this case, the one giving the offer that I am selling my water to you. Please, if you are interested in buying, write back to me through the post. So he has what? Gotten the information. Due to the misdirection of the letter by the defendant, the plaintiff received the offer on 5th September. The letter was misdirected. But at the end of the day, it got to the plaintiff. But on the 5th, it took 3 days before the letter got to the plaintiff. The plaintiff wrote on his what? The plaintiff wrote an acceptance on September 5th. It means the same day. I had the offer today. Then today, no, I responded to it because the deadline is closed. The plaintiff wrote an acceptance on September 5th and posted it that same day. The defendant received acceptance later, an acceptance letter on September 9th, by which time the wool has been sold to a third party. Please, are you getting the picture? So when they say acceptance is by post and is communicated in the offer, that the moment you give the notice of acceptance to the postmaster, the process is completed. That has been done. Now, from the date of the receipt of the acceptance and the day that the information got to the defendant, he has already sold it because he thinks the guy has delayed, but forgot that there's a postmaster in the process. That postmaster is his agent who has delayed the process. What did the court say? The plaintiff acceptance became binding on September 5 when the letter was rightly addressed and posted. That is the rule. We call it the postal rule. So with the postal rule, the moment it is part of our contract that you can communicate your acceptance by the post, it means the postal rule will apply. The rule here is that the postmaster becomes the agent of the parties. There's a relationship, agency relationship. The agency relationship will apply. It means that all mistakes made by the agent will have to be binding on the principal, because you stated it that what? Acceptance should be by post. It means you have contracted the post office as your agent. So if they didn't get the letter to you, you don't blame me. So you deal with your agent. So that's why they went to court. And the guy won because he has done his part by accepting the offer on the same day and have addressed it back to them and handed it over to the postmaster. Please, are we together? Please, let's continue. Okay. When you say the date, you see, the offer is up to what? 5th. The offer was valid to 5th. The offer to buy the wool was for 3 days, was given on the 2nd, and by 5th is expired. So after 5th September, that offer is deemed to be what? Expired. He can give it to a third person. Now, the letter got to what? To the plaintiff on the 5th. That is the deadline. He has also accepted it immediately. Submitted it to the postmaster because they say we can use the post as a means of what? Acceptance. So the person has done it. If he had waited on the 6th before he replied the letter, and by accepting it, he has already failed the process. Please, are we getting the picture? The essence of this case is to tell you the postal rule, how it applies. That's how the postal rule applies. The moment you say that the post can be our means of communication, any document given to the postman, that is why the man too cannot blame the post office for delaying the letter. The letter came on the 2nd, but he got it on the 3rd or the 5th. Luckily, it is the expiring date. What do? Quickly, you accept it and send it back to the same process. So by sending it back to the post office means that he has given it to the owner. That is the postal rule. Yes. Now, acceptance by electronic means. Now we have a lot of electronic means. Email is there, WhatsApp is there, Instagram is there, Telegram is there, all the grams. Twitter is there, Facebook is there, whichever. So if we specify that the letter should be delivered or the acceptance to come by electronic means, specifically WhatsApp. What it means, those of you who have been setting your WhatsApp, say that when people send you a message, even though you have read it, but you don't want it to show that you read it, this is where the law catch up with you. Yes. So you see, the offer is a bilateral offer made on you alone. So you are the one who has the option to accept or not to accept. If it's a unilateral offer, the law says silence is enough acceptance. And the case there was a Catholic Pescabolis mobile. You make it to the whole world. Just like the one they say, a wanted person. Anybody who knows the whereabouts is an open offer. It's made to the whole wide world. The example is the Catholic case. If you know where the criminal is and you can give the same direction to the police, you have accepted that offer. Bilateral. The unilateral, even the response is already waived. The option is there. If you go and buy Procol, will you tell Koja you have bought Procol? You tell them, you go and use it because you are having cold and you want medication that can solve it. And they claim it is quality. Use it. If it fails, you use it according to prescription and it fails. Please come and collect £100. That one is an open offer. Anyone who goes to buy Procol has accepted it. Are you getting me? You don't need to communicate to the company. Because when you bought it, you haven't bought it from a retailer. Okay, are we together? Okay, acceptance by electronic means. I was saying, I'll take your question. The WhatsApp, I know the normal WhatsApp is that if I send a message to you and you have seen it, there's a difference between seen and read. If you have seen it, it will be double tick. If you have read it, it will show blue at my end. And if it show blue at you yourself, your own end. But some of you are so smart that you can set it such that you see it, read it, even forward it, and it will not show. It's all about the setting. If the mode of our communication of acceptance is by electronic means, and we have various electronic means, but we say WhatsApp. Even now, there's something called substituted, when bailiff is looking for somebody to give service, correct? If they are looking for you to serve you court order, and you are dodging, you are always dodging. The law is that it must be given to you. You see the bailiff coming, then you pass here, pass here, pass here, pass here. Because after he didn't see you, he can't give it to somebody else. That is one thing about the serving of notice. It must be served on the person or the person's identified place of residence. If you cannot get the person, but you know this is his house number 25, Belopalsi, go and paste it there. Bam. Whether he like it or not, he will come and sleep in the night. You see that something is there. By one, you cannot identify the person's house. You cannot meet him to serve him. Then what you do is that you go back to the court, ask the court to give you the opportunity to do a substituted services. So if you know that his electronic guru is always online, fire it through any of the means to him. Fire it. The moment it is thick blue, he can't say he has not received it. He will come to court tomorrow. Oh yes. He will come because there's an indication here that he has received the summons which has been served on him. Yeah, yes, your question. There's another question. Yes, please. I see a lady. Can you meet the person for her? Madam, where are you going? Are you the one they proposed where you are going? Yes, your question. You see, the opposition you have gotten from this class alone to give you an indication that that is not a complete agreement. Hey, if you want to do that, then there will be a lot of court cases. Because, yes, the reason why I wanted us to finish lecture 4 before we go to 5 is that at least this lecture 4, there will be a question here. But that's why I want you to go through all the full scale. Now, is the only lecture we've ended up to the last one. Okay, so there will be a full question here. Isaac will take over from next week. By the time you finish, when we are setting the question, about 2 questions will come to you. And Isaac will bring 1. Yes, because I'll just give you a sample. And by the time we finish this, the next slide, you will also see the format of my next question. I say like, just wait. By the time I'm done with the lecture 5, you will see the format of my question. That one is even more than giving you direct question. So please, after the lecture 5, we'll move a little bit faster. Yes, the question that our brother was asking, should we answer it?
Why? Why?
You've gotten a lot of response from the class. For me. Okay. What our brother is talking about, he said that if you propose to a lady and you tell the lady, this one, thank God, is not proposing to all the ladies. You see, when you propose to all the ladies, that is when silence becomes an option because it's a unilateral offer. Anybody who is silent presume to have accepted. But for a bilateral, you want Madam A, so she's the one you are going to talk to. As for that one, the law says silence is not an acceptance. So even if you add condition that I give you 2 days, you don't say, I'm coming with my uncles to come in. That one, no. Yes, madam. Hello. There's a new question, Ajia. Yeah.
Is that there's a husband I think 1 year old.
Yes.
Mm. It's the same profit. Then I see the 1 year old. Then I purchase it. Then I send it open within 3 months. And I go back and they are telling me on the maintenance code. Can I see the?
You see, you will be right when you have the manual and you follow the manual. I gave you a scenario where a guy selling light told me that in selling in Anglophone country is very difficult compared to selling in a Francophone country. Okay. The basis of what he's saying that in a Francophone country, the legal system they practice, the codified legal system, what we call the civil law, most of the informations are written. Their laws are in books. You can just go and buy the law books, read it on your own, and know what you are supposed to do. Unlike our common law legal system, our own are based on the judge's discretion. It's not just strictly on the book. Like some of our law which has been codified is like the criminal act. At least for the criminal act, which we call the Police People's Bible, it tells you all the crime and the punishment available. That is how the civil law works. So the system has made the citizens abreast with reading instruction. Okay, when you buy phone, it comes with a manual. If it's brand new, it comes with a manual. Apart from the one you buy at the central under the bridge there, that the boys. Thank you. The swapping, there's no manual. It's by word of mouth. It's not a wrong contract. It's a valid contract. Because, buy 3 months is valid. 3 months when you go, what they will do is servicing. If you buy brand new, the manual will specify the content of the warranty. If there's a manufacturing defect, okay, there's an opportunity for replacement. If that defect can be serviced, can be worked on, it's at their discretion. Now, if we are looking at all the entire element of contract, when we come to the terms, there's something called fundamental terms and conditional terms. The fundamental terms are things that are direct to the functioning of the gadget. There's something called latent defect and patent defect. The patent defect is something that you can see. This bottle is what? Kept. Everybody can see there's a defect. The bottle is supposed to be straight, but because it's kept, it's a defect. You can see it, but it's not a problem that affects the content of what? The bottle. But the latent one are defects which you cannot see, ordinary eye, even by an expert, you cannot see. So if you go and buy a car, okay, and the fitter or the owner tell you that, oh, the problem is just air condition, and the wiper is not working, and you can see all those things, they are patent defects. But as to whether the engine has a problem or not, it's a latent, because even him who is driving cannot see that one. Please, are we together? So when the defect is a latent one, which the seller does not even know that there's a defect, that one is a fundamental error, which is a breach of the fundamental terms. It must be replaced. When you read the case of Hotel de Georgia versus Silver Auto, yes, it was a case that they went and bought a Mercedes-Benz car. Even the company did not know that there's a problem with the engine. The car was running, then it suddenly went off on the high street. So they returned it that they have to replace, and the matter ended up in court. So the court said, prove that the person did not even know that that problem is there. So that the burden of proof is on you, the plaintiff. Because if it's something that the seller cannot see, you cannot say the seller is aware or knew that there's a problem with the engine and deliberately sold it to you. So as for the latent defect, the law says that you must show all evidence that the seller knew that that problem is there, yet decided to cover it and sell it to you. That is the only case that the law will give you complete replacement. But if it's a patent one, you saw it, that, oh, the glass is broken. Then at the time of purchase, the seller tell you that, oh, it's a broken glass. If you want us to replace, it will cost 2,000. Okay? But if you buy it like this, we'll discount the car for you, 3,000. And so then discount it. I will go and buy it myself, knowing you spend 2,000. And when you leave after buying, and you didn't go to replace, you end up using the car. Then the glass decided to continue breaking, and the damage becomes bigger than you earlier saw. You can't go back to the seller, or you can't go to court demanding a remedy in terms of what? Damages. Because you saw it before buying, and you were ready to remedy it yourself. That is why they gave you a discount in the purchase price. Are we together? So when you buy the thing, the manual is there. The manual will tell you the warranty and the content of the warranty. So that this book is for who? It's yours. Please, are we together? So about the warranty that our sister asked, that is the issue. Then before that, our brother hand was up. I will come out. Warranty. Okay. That's why, as if we should go to the terms. Let me just go to commercial law and bring you this information. So you can bring up your issue whilst I look for them. Oh, if it's out there, we already have a limited time. Let's move to the main issue here. Whilst I look for the. Yeah, this is lecture 5. So let's go. So the intention to create a legal relation aspect. Collateral. Bilateral. And say the marriage between two parties. The offerer, the one who wants to marry, and the one who has accepted to be married. So let's go. I think what we are looking for, we'll get it from here when we move to the next slide. Please, I will not spend time here. I've discussed this at length, that every relationship should have an intention to create a legal relation. If it is not on that basis, then it will be seen as a mere social contract, like the politicians do to us every day. And like our brothers also always bluff to our ladies that, oh, don't worry, I'll buy you this, I'll buy you that. The law says that when the agreement does not have the intention to create a legal relation, it means that if problem happens, you won't go to court. That is the meaning of this. But where we say, oh, I will marry you. If I fail, In 6 months' time, if I fail, take me to court. That one, it means that there's an intention, legal relation. Please, are we together? So there, if the lady also waits for you for 6 months, wherever you say you are going to come, and you come by and say, oh, I've changed my mind, there, the lady can sue you for damages or specific performance. But the thing is that if you force somebody to marry you, there's a reason why he say, I won't marry you again. Even though he has wasted your time, the best that you should ask for is damages. The court should compensate you. But if you say the court should force him to marry you at all costs, you enter the marriage, you will not be happy. So that is about the intention to create a legal relation. The parties can only enforce promises if they mean the promises to be taken seriously. Let's go to the next one. Yeah, so these are the cases I was mentioning the last time. Bafo and Bafo, an arrangement between spouses while living in enmity. They were happy. This is when they are happy. Whatever the woman says, the man will take. Whatever the man says, the woman will take. They are very happy. Now, what happened? Was considered not to create legal intention. So when you and your husband, you are happy, you are roaming all over the place, and your husband say, I will bring you Jesus Christ tomorrow, life. And you have agreed. Because you are happy. 2 days' time, he didn't bring Jesus Christ. The court said, don't bring that matter to court. Because there was no intention that it become legally binding. It was done when you were in enmity, happy moment. Then the court says that, comparing this case to what? Marriott versus Marriott, there's a diversion. An arrangement between separated spouses for conveyance. Conveyance means transferring of ownership from one person to another. Those of you who work at Lands Commission, you see that when you buy land, you go and do lease. It's a process of conveyance. What they do by registering the lease in your name, it is conveyance. They are transferring it, the interest from the chief or whoever sold the land to you. That is the process of conveyance. Transfer of interest from one particular person to another is what we call conveyance. And in abroad, most often, if there's a separation in marriage, most of the time, the women keep the house. Yes, there's a child involved or there are children involved. You don't expect the woman and the child to be on the streets whilst you, the man, occupy the property. The reverse may happen in Ghana, but depending on the position of the law. Okay. Now, so this house particularly was a mortgage house. The man took a loan from the bank, mortgage loan, to buy the house. So every month he needs to be paying for the mortgage. Then what happened? As part of the marriage settlement was held to create a legal relation and was binding. They said what? The spouses for the conveyance of the house as part of what? The marriage settlement. The man is supposed to transfer the house to the woman as part of the marriage settlement. But because it's a mortgage, the man told the woman that, oh, you'll be paying the mortgage for me. Please, are we getting it? They said, oh, since the house will be given to you after our divorce process, there's a mortgage, be paying it for me, so that after whatever happened, the house will be transferred. So there was a document on it. They documented this. So that is why when you are sending text message, it's different from when you are speaking from your mouth. Those of you who work in a bank, when you make a mistake in the amount in words and amount in figures, the law says amount in words supersedes amount in what? Figures. Because for the figures, you are in a hurry. But amount in words, you took time. 100, you spell 100. Ghana cedis. How will you say that was rather a mistake? Okay, that is the position of the law. So when you send text message to ladies promising them, know that that text message can be used as evidence against you. In the Jakpa versus Attorney General, are we not seeing WhatsApp communication the same way? When you are promising, be careful. Because the text message can be used as evidence. But when you say it, and if you goes to court, oh, my Lord, I didn't say it. Because even Peter denied Jesus Christ 3 times. So that's why I say it can be denied at the end of the day. Jesus Christ was denied. How much more you? When I know the case will go, I can deny. I've never seen it before. Though after that, we won't get our payment or judgment day. But to save that matter at that moment, I've run away from it. So the position of the law is that in this case, there was evidence agreement to a payment of mortgages. It is based on that agreement that you cannot compare this case to Balfour versus Balfour. So in this case, it worked in favor of the woman. But in the case of Balfour versus Balfour, it worked in the case of the man because the promises were not just a mere promises. But in Marriott versus Marriott, it was not a mere promise. Okay. Then when you come to Coward versus Motor Insurance Bureau, a lot of us who drive car, we give lift to people, don't we? When you give somebody lift, you ask for money. So when you give a lift to somebody on the road going your direction, there is no intention to create a legal relation. So in this case, they all had accident and they died. Somebody was giving a lift to the friend. They have accident and they died. Then the person who was giving lift, the wife went to the insurance company and said that the car that picked my husband have an insurance, so please give me the compensation. So that is as a wife. So is it Coward? Yes. So that's what the law says. What the relationship there, they did not have any legal, didn't create a legal relation. It was a mere offer, a mere lift that was given. Okay, friendship, social contract. Let's continue. Okay. Then in Percy versus Marima, it was held that a husband may be his wife's tenant and as such could be made to pay rent. I know most men will not agree. Yes, your wife has put up a property for commercial purpose. Now, let's go back to the first page of intention to create a legal relation. Let's look at something here. Generally speaking, in commercial agreement, there is a presumption that the parties intend to create a legal relation. But in family and friend arrangement, there is no such presumption. I am selling fuel. You all know when you are selling fuel, it's a commercial transaction. You are doing it to make profit. The people who build filling station, no money, profit they want to make. But they have family members. If you just walk to the filling station and you keep collecting fuel at the end of the day, and it's not that your son who owns the filling station is the one giving you. You go there and say, oh, let me take fuel, I will pay. Let me take fuel, I will pay. You take fuel, I will pay. There's no presumption that it's a family arrangement. The law says it's a commercial arrangement. So if your wife built apartment, she's renting, then the apartment that you and your husband is, they are ejecting you. And the agent, because unlike Ghana where people go and look for their own room, in the developed world, you contract an agent to look for apartment for you. The agent came back to you, I've seen an apartment at Tipoli. Okay, this is the amount you pay. Then you pay and you move in. Your wife knows that is her house. She will laugh, enter her compound. Okay, the business is rental. She didn't say, please, let's go and stay here. Later, when you get a place, then we'll move. No, she didn't offer it. It's a commercial activity. It's for business. You say, you're angry. The building is for rental. So you are going to rent. It was later you detected that it's your wife's house and you are paying rent. The law says no. Please, let's go back there. In PSU versus Meribah, a husband can be a tenant and you must pay. You pay. The law says you must pay. It doesn't matter whether you are Daguma or you are an Ewema. That is the position of the law. He said Dagoma, man. Dagoma. Okay. So commercial business. I put up apartment. Huh? Hello, please. Hello, do you know that I pay insurance for my car? My wife is working at the insurance company, but the company is not for her. If she decides, yes, it's not a private, it's not a private home. It's not a private home. It's a commercial property. It's a commercial property.
I got to realize that by my wife, right? So if she say I should continue to pay, then whatever I'm doing to her, she should also pay.
How? Let's go. Let me see. Please, I've not forgotten your question. No. I will get it under this slide for you. Yes. Legally, okay. You are. Hello, hello.
Then you find yourself this way. You have to have somewhere. Then you need to be great. But it's not right.
You say morally. Guys, hello, senior. The law doesn't bring morality and legality together. Hello, please, we are learning. The time is very limited. We are here to go to consideration where I say the questions are, please. The question that my brother is asking, the law separate morality from legality. Okay, 2 days ago, I just read in the news that some 2 adults were making love in a washroom in Ankpala campus. Those of you, no, a woman and a man. I saw it on one of the social media and I read. Already somebody called me that he had heard this is what's happening in UBS. And I said, I don't know yet. So later it came on the Utah page. What is their crime? Their crime is the place that the thing was happening. If not, they have not committed any crime. These are consented adults. The only crime they've committed is to do it in a public place.
But nobody was there.
Wait, the public place doesn't need to tell somebody what time to come, what time not to come. That is the problem. But as whether the man was married, the woman was married, if you bring morality, take it to different capture. But legality, they've not committed any crime. Except when one will go and report that I have been raped, then the law comes in under crime. Okay, so the same way, you see, you jump traffic light. Okay, when you see nobody is there, why will I be yellow? There you go. You have committed crime legally. But morally, but he's the only person there. Why should he be standing in front of traffic light? So comparing legality and morality, the law will not favor you when you move that tangent. It's a commercial property, belong to your wife. You are a tenant. The law says you are supposed to pay. That's all.
The cheating case, one of them.
Please, the word you are using new word cheating. That we're told that the rest. That one. Using a public venue to make love or to be having sex is the only problem here. But the sex itself is not a crime. It doesn't matter before the law. It's indecent exposure. Hello? Indecent exposure is a crime. When you take the at 29, hello, please. When you take the at 29, there's a crime on indecent exposure. A Kwapin Polo or whatever his name. Show herself to her own son. Was charged. That's an indecent exposure. You are giving us what we don't want to see. So it's a crime. So doing it where we don't want to see that's the crime. But the sex itself, they are all more than 18 under the Ghanaian law. The law says 16 and above, you are sexually matured. If you are 16 years and above, you are sexually mature in Ghanaian law. But marriage is seen as a contract. For it to be valid under the marriage and the ordinance, you must be 21 years and above before you can go and register your marriage in court. If not, you can only fall under Islamic marriage or traditional marriage. But if you want to go to one man, one husband court, ordinance, the two of you must be 21 years and above. Yes, before this hand was there before. That it didn't happen or so sure. That is fine. But what we have seen is what we are analyzing. That's what we are analyzing, yes. Yes. Uh-huh. No. No. Don't even land. If you land, you spoil the ground. When you land, you spoil the ground. Oh. If you land, you spoil the ground. Have you seen that all the washroom, the door, if somebody is sitting, you are allowed to see the person's leg. You know that. Because it's a public place. In case you are locked up in there, you can call for help. If you read what is online, the person who made this, they were making noise. They were making noise. The woman was moving. Hey. And they, what is happening? So privacy is out. Forget about privacy. Let's continue. Let's continue. Let's continue. Let's continue. Yes. Oh, no. Hello, please. Let's continue. We are left with just 15 minutes. We are left with 15 minutes. Please, let's continue. When we talk about contract, every contract have terms and conditions. Every contract have terms and conditions. The terms, some are express, some are by way of implication or implied terms. Okay, some are implied by conduct, some are implied by custom. Now, when you look at, please, before this slide, let's go for this slide. The one before. So terms of contract, can you go back a bit? Let's see. Okay, so let's go back. Terms of a contract means obligation each side undertakes, the representation made in respect of discharging a contractual obligation. So every contract have terms and conditions which all the parties who are involved in the contract are supposed to comply. When there's a breach of terms and conditions, one who suffered is what qualified for a remedy. So like I said, when you look at your admission letter to be here, there are terms and conditions. One of them is that pay a non-refundable fee, which shows that you have accepted the offer of admission. Okay, if you're able to do that, it means you have met that part of the condition. And there are so many other terms there. But like I said, never did they write about sexual harassment in there. But over there, they will direct you to a policy. So by implication, there's a document for that. They will direct you to what? Exam or practice. But they will not write it to your admission letter that when you come here and you copy, you'll be sacked. But it's implied that when you come to school and you copy, whatever you do which is contrary to the laid down rule is an implied term. So when you breach them, you can be held responsible. But those that are written in the offer before you are those we call express terms. So when you take appointment letter, oh, you have been appointed ABCD manager, you do this, you take this salary. up to the last one, before they say accept, are all express terms. Are we together? Later on, there are other terms in the company that you are joining. Those are implied terms. Okay, let's continue. So, he said, no, before then, please, sorry. A term imposed on contractual obligation, a mere puff is a boast only. So if there's a term, there's a contractual obligation. So like Kali versus Kabolis Mobile, there was a contractual term that if you buy our smoke bomb medication, use it according to specification, and you still contract the influenza, come and take £100. We have put £1,000 in Alliance Bank, complete terms. So any of those terms makes it a complete contract. Okay, but where it's just if not for the money that was put, it would have been a mere puff. If not for the money that was put in the Alliance Bank, see it as a mere puff. And like I said, there's so many adverts in Ghana. Some of the herbal medication can solve problems from your hair to the sole of your feet. That's the advert. But you buy it, your hand will still be paining you because it's a complete, just a mere puff. Assuming they said, if it fails, come to Bank of Africa and take your money. It's a complete term. And it's an obligation on the company to fulfill that when you have done your part. That's why I say, if you go by instruction. So when you buy the phone, you don't start it. They say, first charges should be 6 hours. Then you go and do 2 hours because you are in a hurry to use the phone. When it's spoiled, they will only repair it for you because you have breached the terms. You see, when you go to insurance company, okay, and you want to play smart, the law says there's something called utmost good faith. Sometimes a little delay, they delay you. Your body language will tell them the history behind your claim. It's part of their job, psychological testing. That you push the person small, that this claim is not a genuine claim. Will you pay? The body language will tell you this is a genuine claim or not genuine claim. Yes, Ian. Oh, it's part of marketing. It's part of marketing. Okay. But when the person goes further, like in the case of Kali, it's no more an advertisement for. The law will insist that you do what you say you will do because it becomes an obligation, a contractual obligation on you. That if you use my medication, that's what Kojak will tell you that when you go, request for what? Broco with Kojak boldly written on it. But all this while, they've never told us that they put some money in a rural bank for us to take. Assuming they've done that, it is no more an advertisement puff. Oh, have you heard of Bogoff? Those who do marketing, Bogoff, buy one, get one free. It's a marketing strategy. But the price, you see, this one like this, is a classical example. Buy one, get one free. So this is the one they put on advert. Knowing that when you buy this, you get the same thing. After buying, then they'll give you this one. After they are giving you a phone. But you see that they are not the same. If you go into detail, you see that the price of this is already embedded in this. It's a marketing strategy. So buy one, get one free. You go and buy this only to realize that the one you get free is a small phone. So those of you like buy online, to be careful. You buy a blender which will look like my hand one day. So this is where I want to come. A breach of, okay, let's start from here. Contractual term may be conditions or warranty. Bro, we are coming to your question. The terms may be condition or warranty. Conditions create the fundamental obligation on the contracting party. When it's a condition, it's a fundamental obligation. So when you say the car engine is not working, it's a fundamental problem. Because everybody who buys car knows that the car engine must work. Because that is the heart of the car. For the body, we all know you can go and do body waste. Okay, you're right, you go and change. But the engine, if you change the original engine, you never get it like the original one again. That is why we see the engine as a fundamental obligation. So when it comes to the breach of fundamental obligation, That is condition. One party is entitled to the other party to repudiate. I bought a car from Japan Motors only to realize that the engine is not working. I have to repudiate that contract by sending the car back. This is not about warranty issue. The warranty, they will tell you that 3,000 kilometers or 3,000, is it 100,000 kilometers or 3 years, whichever one comes first. Some of you use the car so much, okay, then they will put those information there for you. But the law says that when there's a breach of fundamental obligation, such an obligation is a condition. It means that one party is entitled to what? To the other party to repudiate. A condition is a central, fundamental, or important term of a contract. We all know that when you are signing any contract, number one thing is the benefit behind the contract. That if you construct this road from this junction to that junction, it's 2 kilometers, you will collect 2 million cedis. So you finish and they say they will not pay you. How will you feel? It means the fundamental terms of the contract has been repudiated. So in that case, it will become a problem to accept such a contract. Likewise, when you buy electronic gadget and the defect is not a manufacturing defect, but it's a usage defect, that is where they investigate to see whether you went by the manual or the instruction. But if you have gone by the instruction and they still fail, then Kali case will happen because it's giving you instruction that if you go by it and yet still you still have problem, we have put ABCD in bank 2. Go and take it. The law will give you the clearance. But where there's no complete terms of the contract, like Kali case, and it's just the fundamental problem which have been observed, or the breach of fundamental condition is what has been what? Okay, like in the case of a car. I mentioned Georgia versus what? Hotel de Georgia versus Silver Star Auto. When any of you go and read that case, you realize that those were the issue. The issue was based on the terms of the what? The contract. And if it's the engine, it is going to be difficult for the seller to know that a small portion is broken because it's a latent defect that even ordinary eye by an expert cannot see. Okay, if you come and take my laptop right now, my daughter has chewed the edges. Okay, this one, you can all see it. But if she has broken the motherboard, can we see? Except expert. Even if the expert do their investigation and say, oh, there's no problem with the motherboard, it's functioning well, go ahead. It means that even if tomorrow you take it and you say there's problem, that problem, even me, the seller, including the expert who did the inspection, cannot even see it. It's a latent. So in that case, it's a fundamental condition. So what do? You repudiate the contract by returning the goods. And that one I will ask you to read because I'm left 5 minutes. I wanted to enter into what consideration, but from look of things, we may not be able to. Okay. I don't know the online, whether I will be given a slot to join online. When we look at the term, the consideration, particularly the various type of consideration. Because the exam question that I have, first you have to define a consideration and the various types. The last batch, those who are in second year now, those who read Bible, even they read Bible, but they didn't understand that passage. There was a passage I brought from the Bible that a man has hired workers. Some people start in the morning. Okay, the agreement is that we will pay 100 denarii. If you bring it to our city, our currency, we will pay 100 Ghana cedis. Then later he met another group of people who are idling and gave them job. Another group till it's 5 p.m. Then he paid them the same amount. And those who started in the morning were complaining. That, how can we started 6 a.m.? Some people started 5 p.m., but the payment is the same. We were looking at it from the law point of view, that if this is a consideration, what type of consideration is the morning session? The people who came in the afternoon, what is the consideration there? Or what is the type? And those who came in the evening, what is the consideration? There are 3 types of consideration. We have executed, executory, and past consideration. So we need to understand these terms, what it means. Okay. I'm sure we are done with the terms and the warranty. So a warranty are also terms, but warranty creates a minor obligation. So you see, when they give a 1-year warranty, when you sell your food, they only repair it. Yes, it's not what? A condition. So this is where guarantee will come in. A guarantee is more or less like a fundamental obligation, unlike a warranty, which is a minor obligation. Now, let's continue. So this is just a case. Let's move on and see whether there's another. So these are the other terms. Contractual term may be expressly agreed upon by the parties, by the implied term, which is called assumed by the parties. Then there are some of the terms which are by statute, by law. When you take the tenancy law, the law that regulates tenancy, one of the provisions is that when a tenant rents your apartment, the landlord, you are supposed to allow the tenant peaceful enjoyment. That one, they will not write it in the contract term. It's already by law. The statute has already made it clear. You have to allow your tenant to enjoy the apartment peacefully until the rent expires. I heard of my people in Accra and some part. They rent for you. The next day they will sleep in front of their own house. I don't want to mention any tribe, but I mean my people in Accra. They will tell you it is a room you rented. The outside is still for them. So after they rented for you, they will still sleep in front of the apartment they rented for you. The law says what? The tenant is supposed to have a peaceful enjoyment of the place. So if you are intruding on the tenant's peaceful enjoyment, there's an implied terms that the law cannot trigger. Okay. Then implied by custom, there are some businesses or there are some professions. The way they do their things has already been agreed by all of them. Ghana Medical and Dental Association, they have their way of doing things. Okay. Some of them are lecturers. But let there be a strike by UTAC. They can choose not to be part because they will tell you they are doing essential services. They will go back to the hospital and be working. Essential services. Let there be salary agreement among the Ghana Medical Association members. And they say, don't share it. UTAC can cry and go to heaven and come. As long as you are not a medical practitioner, they will not give you that information. The custom within their field is what they are working with. So there are certain customs, terms that they are implied just by the custom of what? The profession. Are we together? Then the last one is by court. Sometimes the court can bring in its terms. Okay, when there's a dispute and we go to court, the court will look at the merit of the 2 cases and introduce new terms to the contractual agreement. So apart from the express terms, like the employment term that we see, there are other terms which are part of contract and must all be respected in every contract. And these are those terms, implied terms, which by assumption and by statute, by custom, and also by court. So this is just an explanation of the various terms. You are not scared. So you must show. Don't say you come here. So for the purpose of exam, I will not put any question on capacity, but the note is there. If you have problem, just put the question on the page. Yes, I follow your page a lot. Now that the politics is over, can we now close some of the pages which were used for politics and focus on our page, please? You are one of the campaign managers. Please, some of the political pages that were created prior to the election, let's close them and focus on the 2024-2025 NBA page. By appointment, sir, he's president as well, so they will not appoint him. Let's wait and see what happens. If they will not come back and fight like our president and his people are fighting. So, please, if you read any of the notes, I beg you, I am active on that page. I see everything that you do. If you have any problem with any of the notes that has been given to you, from lecture 1, 2, 3, 4, and the fifth one, which will be put there today, just put it if you cannot send me private mail. If you cannot DM me personally, just put a question there. I will respond to it for you, please. Okay. Consideration. Can we use just 10 minutes, please? I beg you. We have exhausted the 2 hours, but can we use 10 minutes just to introduce ourselves to the course? I beg you. 20 minutes. I beg you, Ajia. This case. Okay. One thing about what we call the judicial decision or judicial precedent, there are times that a matter will go to court and the court will give you their definition, how it's supposed to be. Okay, something called element or thing that must be present for the court to see that A, B, C, D has happened. This is a definition by the court, as in the case of Courier versus what? Nisa in 1875. It's a UK case. Now, they define consideration as any, in the sense of the law, it consists of either or some right, interest, profit, or benefit accruing to one party, or some forbearance. Forbearance will apply where somebody has promised somebody that I will marry in 6 months' time. If I don't do it, you can go to court. It means that for that 6 months, she will forbear other better men who will come her way. It's a consideration that she has given. For staying for 6 months and wait for you, either you are going to look for money in UK or Dubai and come back. Then after coming back, you say, I won't marry you again. Her consideration in that agreement is the forbearance. She cannot take you on because she has given consideration to your offer that you presented. If you read what's called privity of a contract, under the common law, if you are not giving any consideration to any contract, you don't qualify to enjoy in that contract. So, for example, I have an arrangement with my sister. The husband is there. He's not aware, he's not party to this contract. If there's a breach, he cannot take the matter to court because he's not part. But the Ghanaian law has made changes that if you are a beneficiary in that contract, you qualify to take it to court. That is on privity of contract. If you are not a party to a contract, you cannot enforce that contract. So these are the definition of a consideration. A detriment, loss, or responsibility given, suffered, or undertaken by the other party. This is how the court defines what we call consideration. In the case of what? Courier versus what? Nisa. Then our famous case has come here again. In the case of Kalik versus Kabolis Bobo, Bowen LJ defined consideration in the following words: an act of the plaintiff from which the defendant derived benefit or advantage. An act of the plaintiff from which the defendant derived what? Benefit or advantage, or any labor, detriment, or inconvenience sustained by the plaintiff, provided such act is performed or such inconvenience is suffered by the plaintiff with the consent, either expressed or implied, of the defendant. So you see that when the company was advertising their product, they say anybody who uses a smoke bomb medication and follow instructions, and after a certain period, you have still contracted influenza. It means that they have given their consent that when you use it and it fails you, come for your money or come for £100. And for us to tell you we are serious, we have put £1,000 in our Alliance Bank. That is the consideration of what? The company. By putting £1,000 was the consideration that made the offer a complete contract. Are we together? So that is the definition by what? The Then, it said from the above definition of consideration in courier case, it can be seen that consideration may consist of the following: an act, that's doing or something that the other party has specifically requested. 2, forbearance to act, not acting or exercising one right at the instance of the other party. I have forbear, I've decided not to enjoy some things just because of your offer. Then the exchange of promise, relying on one's promise and acting to one's detriment. There will be what we call equitable estoppel. When you ask that I wait for you, you are going to do your school. The ladies who always promise the men, oh, let's finish school before we marry you. And the man keep giving you money, waiting for you. Then after that, he say, we will marry you. That is the exchange of promise. The acting based on one's promises. You cannot come back and say, no, I won't marry you because you are not my class. Problem will happen. Have you moved? Oh, no, okay, then let's go. So the act must emanate from the person seeking to enforce the contract and must be about what is specifically requested by the other party. Okay. Then they say the performance of the requested act, even if enjoined by a legal duty, can still be considered as consideration on the basis of which performance of the contract may be asserted. So this particular one was what happened in the case of what? The Kessie versus Chamat. The job that Kessie did was already enjoyed by law, by his legal duty. As an ambassador, it was his duty to help the countrymen to make money or make business in the foreign land. But even though already that job or that duty is legally his duty, if he performed it, he has also done what we call a consideration, which entitle him to enjoy. But because of what we call the Public Service Act, that deny him from getting the 5%. If not, the law says what he has done is enough consideration for him to get what he deserves from that promise. If you read that case, it's in one of the slides, Kessie versus Chamat. Okay. In other words, the act that the person relies to enforce the contract may be part of his legal duty or obligation undertaken by him in the performance of his legal duty, but will be sufficient consideration. That is just a confirmation of what? The Kessie versus the Chamat case. That if you pick a policeman, already we have a security man there. But when we pick a policeman, that, oh, come and give us protection. We heard that some Azoka boys or Kandahar boys want to come and destroy this place. We bring the policeman and co. We are supposed to give them what? Some motivation. Even though what they are doing is their legal duty as a policeman to protect citizens. But yes, they are doing it in their office. But if you say, come to my house, there is an extra duty. You are supposed to what? Commit. Yes. Like motivation. Ask the bankers. When they ask you, come and give us escort, we are moving money from Bank of Ghana to the office. They pay them for that. They pay them for giving them the escort to carry what you call the specie movement. They move money, they pay them for that. And so that is the case I'm talking about. Kessie versus Chamat and another. When you read the case, you see that a Public Service Act of 1960, he was not to make profit from his position in the performance of his official duty, that his conduct was contrary to public policy, even though by law what he has done is enough consideration which entitle him to enjoy the 5%. Just because he's doing a public duty as an ambassador, the law says that he's not qualified to enjoy extra from what he's supposed to do. Let's continue. So these are the amendments that have been made. So Section 9 of the Contract Act, that is the Ghanaian position. The performance of an act or the promise to perform an act may be sufficient consideration for another promise, notwithstanding the performance of that act may already be enjoyed by some legal duty, whether enforceable by the other party or not. So the amendment that a Ghanaian position has brought to the Contract Act is that even though Kessie is qualified, if not for the Public Service Act, okay, by the law itself alone, under consideration, is qualified to enjoy the 5%. But because of the Public Service Act, which deny every politician or public servant from working and collecting extra duty allowance, if not, the law would have favored the ambassador. That is the Kessie. That is why this day when you go, you pay the 10%, cash in hand. They want it now. They don't want to finish the work for you. Then you refer them to this case that they have signed public service oath. So if you go to the public service and they are looking for money, it's because they don't want to finish for you. Then you tell them that, but you were doing your official duty. No, nobody wants that case to happen. That's why they take their 10% before they do their work, which is wrong. It is wrong. But it has become a norm. We are in a system where we have accepted a lot of wrong to be right. And it becomes difficult for one correct person to change the system. Okay. So in the case of forbearance, let's continue. I want to get to the types of consideration. Let's continue. As for this one, you can read them. Yes. Types of consideration. Okay. We say what? The determination of whether consideration is executed. So these are the types we are seeing. We have the executed or executory. It's based on whether there has been a performance of the act constituting what? The consideration. So let's follow here well. Is the act. The act which constitutes the consideration is what we have to look at first. Is the act done immediately? Is it done in the past? Or is it going to be done in the future? That will tell you which type of consideration you are dealing with. So in determining whether consideration is passed, one has to look to see if the act constituting the consideration preceded the agreement. Preceded. When you have done the work already, and you are now coming for us to negotiate the payment, it is the past consideration you are coming for. Because you have already finished the work. You are now coming to bargain how much should be paid. And most of the time, the court does not want that type of problem. Because it will be difficult to enforce.